All right, so this is the third video in our series on the intersection of estate planning and crypto. Let's get into some of the trust design considerations when we're dealing with estate planning with crypto assets. Now, again, just as a quick note, I guess, our estate planning practice focuses on really sophisticated, multifaceted estate planning for ultra affluent families. And we now are to the place where a disproportionate number of those clients have significant crypto asset holdings. So some of these solutions will impact revocable living trusts, but they'll also need to be considered in the context of limited liability companies, operating agreements, investment policy statements, as well as the entire host of sophisticated estate planning strategies, all of your various irrevocable trusts, whether they're charitable split interest trusts, whether they're non-charitable split interest trusts, whether they're irrevocable non-grantor trusts, spousal access trusts, grantor retained annuity trusts. The issues that we're going to talk about in this video will apply to any type of trust where the client has significant crypto assets. One of the first things to think about is, where do you park this thing? We need to be thinking from a broad perspective jurisdictionally. Most estate planning attorneys realize that there are competing bodies of law that are out there among the various jurisdictions across the United States. There is a predominant move towards what's referred to as the Restatement Third approach, which is embodied by the Uniform Trust Code, which is the acronym here is UTC. The Restatement Third approach is a significant departure from traditional common law of trusts in the United States that predated the Restatement Third and predated the UTC, and that's the Restatement Second approach. What's the big deal here? Well, the Restatement approach, the more old-fashioned approach, views trust design and trust administration and interpretation primarily from the perspective of the settlor. So what does the settlor want? The settlor's intent, the person who establishes the trust, their intent becomes the North Star. And so in a restatement second jurisdiction, a more traditional trust jurisdiction, the settlor's right to dispose of their property carries a lot of weight. In more modern jurisdictions, the Restatement Third approach and the Uniform Trust Code approach is to flip that upside down a little bit and primarily view trusts, interpret trusts, administer trusts from the perspective of the beneficiary's rights. What does the beneficiary receive in the context of the trust? Now, that poses some challenges because quite often when the trust is viewed through the lens of what the beneficiary receives, that carries with it the lens of what the creditor might receive if a creditor sues a beneficiary and can now stand in the beneficiary's shoes. So we see that in more protective trust jurisdictions, they're actually the more traditional trust jurisdictions like Nevada, like South Dakota, like Wyoming, handful of states like that have become the kind of the dominant trust administration jurisdictions follow more the Restatement Second approach than the Restatement Third approach. They view the trust through the settlor's right of disposition and place a higher value on what the settlor wants to accomplish. Now, yes, Wyoming is a Uniform Trust Code jurisdiction. However, Wyoming enacted a very modified version of the Uniform Trust Code, and so this perspective of elevating beneficiaries' interests over the settlor's intent did not carry through in Wyoming. So although Wyoming adopted elements of the Uniform Trust Code, it is not really a UTC jurisdiction. And interestingly, Wyoming is the jurisdiction of choice when crypto is in play, because Wyoming has a complex comprehensive body of crypto-specific statutes. There's a blockchain coalition active in the legislature. The Wyoming legislature, the Wyoming governor has been very affirming of crypto asset and blockchain related laws. So in my mind, when crypto is in play, there's almost no other jurisdiction we're we're going to use if we're doing domestic U.S.-centered planning. Also, we need to be thinking about where are we going to find crypto-savvy fiduciaries. So again, Wyoming has got a growing body of professional fiduciaries who are savvy with crypto, but also just kind of generally from a trust design perspective, we need to be thinking about when crypto is in play, who can be involved in the client's plan. We believe that a trust ought to include a clear preamble expressing the settlor's intent. And this is true whether crypto is in play or not. Again, if we're trying to view the trust through the lens of what was important to the settlor, we need to say what was important to the settlor. So that gets carried forward in a clear statement of the settlor's intent. And when crypto is in play, I believe it's worth including a statement that expressly authorizes crypto assets as an investment class. From a design perspective, I'm a big believer in directed trusts where we kind of fragment the trustee's role according to various power holders. We use trust protectors. Colorado uses the terminology trust directors. Other jurisdictions use trust advisors. It's functionally very similar, where you'll have a trustee who is responsible for the day-to-day operations of the trust and hold what's called situs, or the home of the trust, for administrative purposes and for tax purposes. But sometimes we'll fragment that trustee's responsibility across investment decisions, distribution decisions, things like that. We might very well even have a crypto asset trust advisor whose role is expressly to manage crypto assets held by the trust. We need to be really clear to modify or potentially waive altogether application of the prudent investor rule. Every state has some iteration of a standard that says what a trustee is and is not authorized to invest in as part of trying to ensure that the trust remains solvent for the beneficiaries and all that stuff. The prudent investor rule is a default rule. It's not a mandatory rule, and so it can be modified. But because crypto assets constitute a very nascent, currently highly volatile asset class, it's an unconventional asset class, we believe that you should modify or waive the prudent investor rule as to crypto assets if that is consistent with what your client wants. We are usually authorizing concentrated investment positions. Most of our clients who have crypto are very bullish on crypto. It constitutes a disproportionate amount of their wealth, sometimes in the tens of millions or hundreds of millions of dollars. And so they do not want their trustee to have to diversify those holdings. They want the asymmetric concentration of portfolio in crypto. Expressly authorizing holdings in crypto and potentially authorizing additional acquisitions of crypto, even if the client is incapacitated or now deceased, or in the context of an irrevocable trust with a third-party trustee. We've spoken in previous videos about income-generating crypto activities, whether it's through lending out, renting out, or leasing out non-fungible tokens, for example, or participating in DeFi activities through staking, liquidity providing, things like that in the DeFi space. If the assets are held inside of a trust, is the trustee authorized to do that, to engage in that type of activity? When the time comes to make distributions to beneficiaries from the trust, can the trustee make distributions in kind? Or does the trustee have to first liquidate, recognize gain, and distribute net fiat proceeds to the beneficiary, for example? The trust needs to address these things. We also do a lot of discovery with clients around their priorities. And in my own personal estate plan, I've got various thresholds above which my trustee has to enact a different type or a more sophisticated type of private key management. Perhaps even requiring the trustee to onboard the trust with a professional crypto asset custodian once the crypto reaches a certain threshold. So authorizing the trustee, guiding the trustee through the private key management protocol. We believe it's worth including provisions that authorize or potentially even require the trustee to acquire fiduciary liability insurance to protect the trust from loss due to crypto asset investments. And yes, there are actually underwriters who will provide that insurance. I don't believe this is necessary, but I do believe this is the best practice. That if the trustee is going to engage in crypto asset activities, especially DeFi, where they're lending crypto assets, they've got collateralized Bitcoin, for example, and subject to a loan, or they're staking, they're providing liquidity, they're doing other types of activities that might lock up the crypto for a period of time, consider obtaining a beneficiary's consent and waiver authorizing the trustee or not holding the trustee liable for those types of crypto asset activities. And related to this, if there's a beneficiary who is underage, they're a minor, or they're incapacitated, consider allowing the beneficiary to have a virtual representative to bind that beneficiary and thus give the consent and waiver for those types of activities. Again, I believe all of these things can be drafted in, but I believe that if they're not drafted in, the trustee probably would be in breach of a fiduciary obligation by engaging in these activities. Consider resizing the trust from wherever jurisdiction it might be to a more favorable jurisdiction. Again, I mentioned previously, Wyoming. Wyoming and South Dakota are about the only two U.S. domestic jurisdictions we're putting trusts that have crypto assets. Switzerland, Cook Islands are some other options as well. Liechtenstein for clients who are looking to move assets offshore. But for most people, Wyoming is going to be the jurisdiction of choice. In the case of inherited trusts, which is how we design all of our trusts, where a beneficiary receives a long-term trust for their inheritance, are we going to authorize the trustee to have kind of a pooled wallet where all of the sub-trusts are underneath one crypto asset account, or is the trustee going to be required to segregate that out? We should address that inside of our trusts. When the beneficiary has the ability to control their own trust, maybe become their own investment trust advisor, for example, should the beneficiaries be able to engage directly into crypto activities or direct crypto activities within their trusts? Again, certainly the trust could distribute could distribute assets out to the beneficiary, and the beneficiary does whatever they want to with it. But if the beneficiary prefers the privacy and the inheritance protection, the asset protection that can come with an inherited trust, why not allow them to then direct crypto asset activities if that is consistent with the client's objectives? In the case of DeFi, where we've talked about, will the trustee be able to lend the crypto out and generate a yield? Can they participate in staking or liquidity providing in a DeFi space where the trust can actually earn additional yield off of the crypto assets? Is there a mechanism to appoint a specific fiduciary who can then manage the crypto asset investments? We believe that's worth drafting in. Is there the ability to appoint and delegate multi-sig or multi-signature wallet participants? We'll talk about multi-sig. I'll try to talk about multi-sig in a way that makes sense in another video. But the idea here is that when we can diffuse control over the crypto assets by requiring multiple parties to be involved to facilitate a transaction, if the trust requires a multi-signature control, how do we get those multi-signature service providers appointed? And so the degree to which we need to focus on specific drafting issues in a client's estate plan is going to depend in large part to how significant the crypto is in the client's overall plan. If they are simply looking for short-term, transient, minimal exposure to crypto and don't plan to hold crypto for a long period of time, perhaps we don't need to go through a whole lot of these drafting exercises that we spent the last several minutes talking about. But our clients who we have in the space have significant crypto holdings in the millions to tens of millions to, in some cases, hundreds of millions of dollars in crypto. They're long crypto, they're bullish crypto, they're believers in the world of crypto assets. And so when the clients are deeply committed financially and emotionally, psychologically, strategically, we need to make sure that the legacy planning that we do for clients in their trusts and the other entities that we're creating in their estate plan contemplate managing these assets over time. That's also going to impact the selection of the fiduciaries that the client has. So, for example, for strategic purposes, whether it's asset protection oriented or privacy oriented or tax oriented, we will often have trusts and other entities established under a protective jurisdiction, again, like Wyoming or South Dakota or the Cook Islands or something like that. And so we'll need a fiduciary, we'll need an administrative trustee in that jurisdiction. But we may want to have a different fiduciary who manages the investments inside the client's trust portfolio. And some trusts may hold crypto and others may not. So it may be appropriate for us to have different types of investment advisors or investment trustees. So as we're designing trusts for clients who have exposure to crypto markets, we need to be thinking a lot about the trust designs, but also we need to be thinking about the language inside those trusts, as well as the selection of fiduciaries and the situs where we put these trusts in the very first place. So thanks for your attention, and look forward to seeing you next time.